everybody. Thank you very much for coming to this talk held by the University of London Bachelor of Law. So beside me is our guest speaker of today, Dr. Nisha Mohammed. She has very kindly to agree to do this talk because she has a very tight schedule. She is a barrister at law in Hong Kong as well as in UK as well. She is going to fly out to Oxford University for training, advocacy training tonight. So very tight schedule. I'll just pass the time to you. And also, very importantly, Dr. Nisha Mohammed is also our tutor for the University of London Cert HE program, the Certificate of Higher Education in Common Law. So she is kind of like a private tutor for our Cert HE student. She also understands Cantonese, both Cantonese, English, and a little bit of Pudong Hua, I assume. Okay, all right. I'll pass the time to you. Thank you very much.
Thanks, Tiffany. All right. Thanks everybody for coming today for today's talk. Now, I know the title today is in relation to contracts, right? But can I just get a little bit about your background? What level are you? Like, are you studying
Law student?
Law students? No. Oh, so you're interested in studying law? Oh, okay, good. All right. So anyway, so today's course will be a bit more high level, so it's more easy for you to understand, as opposed to actually going through all like 100 cases, because then it becomes too complicated. And I've only got like an hour or so to go through the stuff with you. So the topic that's been picked today is in relation to contract. Okay, so contract law is a very important area of law. And just generally. Now, of course, I'm sure you might think, I don't need to worry. I don't think I would, have anything to do with contract law. Now, can you think of something in your daily life that would involve contracts?
Mobile phone plans.
Yeah, mobile phone plans.
Insurance plan.
Yeah, insurance plans. What else?
Employment contract.
Yeah, employment contracts. When you get on the bus, that's also contracts, for services provided and payments for consideration, right? So actually, everything, even in daily life, would touch upon contracts. Now, the thing about contracts, which you always have to be very careful, and when you do contract law, substantive, you will actually see, contract law looks a lot at the wording of contracts, correct? So remember, like insurance plans, or say, for example, telephone plans. When they give you the policy to read, you will see that there's already a lot of wording in the policy already drafted, right? And then of course if you say, well, I don't agree to this wording, I don't agree to this clause, can we cross it out? Do you think the insurers or the telephone plan companies will be willing to, okay, I will listen to what you say, okay, I think your terms are good, I will amend the contract now? Are they going to do that? No, right? So those are very standard worded contracts, correct? So it's either you accept or you don't sign. You go somewhere else. Okay, now of course, there's the beauty to having that type of contract, because let's say from the company's point of view, the wording is all there, right? They don't need to worry too much because they probably got legal advice on the wording. But then of course, on the other hand, the problem is the benefit. Like whose side is the contract helping, correct? Now the thing that you have to note, and I think which will be today's topic, is about looking at the details, the wording. What is the meaning? What is the effect of the wording of a contract? Because remember, there are consequences, correct? Okay, so I will go through some general backgrounds, because now I know that you guys don't have any background in contract. Okay, so I think I should start off with giving you a bit in terms of the idea of a contract. So normally, when you say that there is a contract in law, you have to prove. So if I say that there is a contract between me and you, right? I have to prove that there is a contract, right? Because I'm claiming that there is a contract. Now for contract, and because remember contract is tort, right? Contract law is basically agreement in terms of the wording of the contract. So there are certain elements. Now do you guys know what elements means? Elements means that there are certain things that have to be proved, okay? So what is the first thing that has to be proved? You have to show that there's the intention to create legal relations. So there are steps that have to be shown, and if you have satisfied all of this, then there is a contract. Is that clear? So the first thing that you have to show is that there is intention to create legal relations. So if I come to you and I discuss that I want to sell this projector pen to you, but I have actually no intention of actually selling it to you, then is there a contract? Even though you may think that, there is you said you would sell this to me, but now you're not selling it to me, there's a breach of the terms of the contract, I'm going to sue you. Can you do that? No, right. So you have to show that there was the intention between both parties. Now remember, intention is something that is in your mind, right? So unless you say it out, or you put it down in writing, or by conduct, then you can prove that there is an intention. Okay, now the usual standard ones will be the wording of contracts, and then you can see what is discussed. Now, for commercial transactions, and actually this applies to any type of contract, whether it's a consumer contract, whether it's a commercial contract, you have to show that when the parties entered into that contract or agreement, there was the understanding that we would be bound to the contract, okay? That we would be tied to the legal terms of the contract. Is that clear? Okay. Now, and as I've said, if you want to rely on the contract, you have to prove it. Now, just by way of background, guys, for civil, it is the parties to the contract will be the plaintiff, who is bringing the action, and the defendant, who is defending the action. Is that clear? Okay, so let's say use the telephone plan example. So let's say PCCW, you have breached the contract. PCCW will sue you, right, for breaching the contract. Then who will be the plaintiff? PCCW, because they are bringing the action. And who will be the defendant? You will be the defendant, okay? And remember, for civil cases, the proof is on a balance of probabilities. So balance of probabilities means if you can show that that was what the agreement was, then it's different from criminal. Criminal is that beyond reasonable doubt. That means you have to be sure, because crime, you're going to jail, right? Civil, you're paying either damages or you ask for a certain remedy, okay? So remember, when I say that if you rely on the contract, it means if the plaintiff relies on the contract, then he has to prove, okay? So what is the first thing they have to prove? The intention to create legal relations. Now, the other thing in relation to contracts is that you have to have an offer. Now, when you guys actually study contract law, this area is not as easy as it looks, but because today I've only got an hour with you, I can't go into too much detail, so I'll just go very high level, as long as you get the concepts, okay? Now, for offer, it means that, so remember, in law, there's always definition. Okay, what is the meaning of something? So say, for example, offer. What is the meaning of offer? That means that you are willing to be bound by the terms that have been specified. Okay, so say, for example, if I say, I want to sell my watch to you for $100. Okay, am I making an offer to you? Yes, because I'm offering to sell you. So if I use the words, I'm offering to sell my watch to you for $100, right? But what if, say, for example, I put my watch in a shop display, and then you come and you look outside my shop window and you like my watch because it's very beautiful, and then you come in and say, I'm selling the watch, by the way, right? But you come in and say, oh, $100 is too expensive. Can you take 90? So there's a lot of issues in contract law. Then when is there an offer? Who is making the offer, right? Is an offer an offer? Because remember, there's two things when you look at offers, when you look at that thing. It's called an offer, which is I'm offering to sell my watch to you for $100. Or is it an invitation to treat? That means I'm putting it on display and I'm waiting for somebody to come and make me an offer, right? Then it's an invitation to treat. Okay. Now don't worry if you don't know all of this now, because this is all contract law stuff, but just so you have an idea, okay? So when you look at offer, sometimes you'll also see something else which is called an invitation to treat. Now, if there's an invitation to treat, so if you come to my shop and you stand outside my shop window, and then you say, Ms. Mohammed, I want to buy a watch, but I want to pay 90, then me putting my watch on the shop display is not an offer. It is an invitation to treat. Is that clear? And if there is an invitation to treat, there is no contract. All right, so that's what you'll see, and this comes back to our topic about fine details and the wording and the actions of the parties and the intention of the parties. it will affect the whole contract, whether there is a contract or not, okay? So just remember, if you agree to the offer, that means that you will be bound the minute it is accepted. So if I say I'm going to sell my watch to you for $100, and you say, yes, I want the watch, I will buy it, then I'm bound. And you will be bound under the contract because there's intention between both of us. Okay, now there's a lot of cases. Now I don't put all the cases because this in itself is another 3-hour lecture on contract law. Okay, but remember, in law, anything you can do or cannot do will be given in the cases. So in law, you will see you'll be studying hundreds and thousands of cases as you actually do the program. All right, so every case gives you a principle. So how do you know what will be an offer? They will look at the reasonable man test and the objective test. Okay, now this is a total different area because the objective test basically means you look at a reasonable man. When he looks at the parties negotiating, would he think that there was intention to create legal relations between the parties, right? Unlike subjective. Subjective is that you yourself, what you believed. Is that clear, guys? Okay, so just note that. Now these are legal tests and legal principles. I don't think you need to know too much for today's purposes, but just as an idea, okay, since I think you guys would like to study law in future as well, okay, so you can have some concepts. Now, the second thing that has to be shown, now first thing is of course the offer. The next thing that has to be shown is the acceptance. So, if I sell my watch to you for $100 and you say, Ms. Mohammed, I will buy your watch for $100, have you accepted the terms? But you said, I will buy. You have, okay? That is acceptance. All right, so basically, if I make an offer to you and you accept exactly the words, the offer that I'm making, then there's a contract. Is that clear? Now, if I say, for example, I'm going to sell it to you for 100 and you say, I don't want 100, can I pay 90? Then that is not acceptance. Is that clear? So acceptance means you accept exactly what the offer is being made. Okay? So basically the words, I accept your offer, will be clear wording. Because remember, as I've said, you have to show intention, right? Intention comes from action, it comes from conduct, it comes from words, okay, or behavior. Now, if you negotiate, that is not acceptance. Is that clear? And finally, if you have an offer, if you accept the same terms of the offer. Is that clear, guys? Right, and you can have a look at the cases if you've got time, but those are just the general principles on what's the definition of acceptance. Is that clear, guys? Yeah, all right. Now the next thing is consideration. Now, do you know what consideration means? So in my example, I offer to sell my watch to you for $100. You say, I accept to buy your watch for $100. And then you give me $100. That is the consideration. The money. Is that clear? Now, the money, now sometimes it may not be money, right? It can be a benefit to me. All right, so basically, one party has a benefit and one party has a detriment. Okay, now, for consideration, there's a lot of case law on what is consideration, what is sufficient consideration, right? Now, cases seem to suggest that it doesn't have to be adequate. You don't have to say that for there to be consideration, it has to be $100,000. Even $10 for my watch is still consideration. Okay? So the cases say that you don't have to have, it doesn't have to be adequate. So say, for example, it's supposed to be £1. I spelled it wrongly. So there was a property. Okay, so an example of the cases. Now remember, in law is a subject. So let's say, for example, I come to you and I say, I sold my watch to one of the students. She hasn't paid, but she has accepted the offer. I want to sue her, right? Now, how do you, if you become lawyers, tell me what is my chance of winning in court? Should I sue? Will I win? How do you tell me this? You have to look at previous cases, the old cases, which give you the principles, and then apply it to your situation and then advise. Okay, so you will see when we go along, we have many, many cases which give you the principles and tell you how to argue it. Now remember, in law, there are always two sides, right? The plaintiff and the defendant. So plaintiff will be relying on many cases, the defendant will be relying on many cases. Okay? So here's an example of how you can look at cases in the future. So in Thomas and Thomas, this is an 1842 decision. Now, all cases usually are the ones that give you the principles. From many years ago, they had it, and then now you maybe have adapted legal principles. So in this case, there was a rental property, and it was being sold for £1. Now, of course, in those days, that's a lot of money. Okay? Now, the court was dealing with whether the value of the rental was significantly higher than £1. So basically, they were arguing, is £1 enough for there to be consideration? Right? And the court said that is okay. It is sufficient. So it does not need to be adequate. As long as there is some consideration, it is okay. Okay? Now, another thing, for an example, what would be economic value? Okay, so you must have some economic value. So in the case of White and Bluet, which is an 1853 decision, what happened was the father said, I will not collect your debt, but you have to stop complaining about my will. All right? Now, there's no money going between them, but he has said, if you stop complaining, then I will waive your debt. The court said, would that be unenforceable? The court said that was no economic value, okay, and it's unenforceable. Is that clear? Okay, so again, guys, remember, when you do law, you have to look at many, many, many cases. Okay, but today I'll just give you some. Now, the other thing that has to be proved, the fourth thing that you have to show is consideration. Now, what is capacity? What is capacity? Can anyone enter into a contract? So can a 3-year-old come to me and say, oh, I want to buy your pen, or your watch, and then I say, now breach of contract, I'm going to sue you, I'm going to take you to court? No, okay? So you have to make sure that they are of age requirement to form a contract, right? And in Hong Kong, it is 18, all right? Now remember, what if I'm a mentally challenged person? I don't understand the words of the contract. I don't understand the complexity. I don't understand the effect of the contract. Then, would that be okay? Can I sue? And say, oh, she totally understood what was going on, even though she has the IQ or the mental age of a 5-year-old, right? Okay, so those things also have to be proved. The capacity of the person. And then, of course, the next thing you have to show is that there is certainty. So basically, as I already said to you, certainty means that the terms have to be very clear. And that's what we will be looking at today, the terms of contracts. Now, if the terms of the contracts are very vague, because they're not clear enough, so when I look at it, when the court looks at it, and the court says, well, actually, I'm not really sure what the meaning of the contract is, then you have problems. Right? So you have to make sure that when you are reading contracts, and if you are advising on contracts, or when you are amending contracts, you need to know what is the importance of the wording and the effect of a contract. It has to be clear. It cannot be vague or ambiguous. Right? Now, there are many situations, and that's why we have so many cases in contract, because things are not clear. Things are vague. Then there's a dispute between the parties. Okay, so remember, if you are not certain in terms of the wording, then the contract is not valid and it's not enforceable. Okay, you can look at the case if you want to. Now, which comes back to our topic today. So that's just general background on what is contract and the importance of looking at the wording of contracts, okay? But now, why is it important that we have to look at the wording of a contract? Okay. Now, remember, all the words in a contract is there for a reason. Correct? Yeah. You're not going to have a contract where there is irrelevant terms in the contract. The terms in the contract are there either to protect one party or maybe to the detriment of another party. Correct? And it may have legal implications. And the usual one would be, if there's a breach of contract, you'll be sued. It's just that simple, right? And then when there's the dispute between the parties, what happens? The contract comes out, right? Then what do parties do? They start looking at the wording. and then they will say, oh, this is not what you are defining the word to mean, this is a separate definition. And then you have the dispute. Then depends on who wins the litigation. But remember, at the end of the day, why would people go for litigation? Why do you think people go for litigation? Tiffany's putting her fingers together. Yeah, money, right? Or you might say, I want to be put back in the original position. I don't want money, but I want to be put back in the original position prior to me entering into the contract, right? Okay, so there are many reasons, but of course the usual one would be you're suing under the contract because you want to claim damages, right? Or you're seeking a remedy from the other side. So as I've said, what normally happens is the parties will agree to the terms. Then there is a dispute between the parties. And why is that? Because as I've said, maybe, let's use our telephone contract document. I sign on a contract for every month, let's say $300 package, right? Then suddenly I see somewhere else, or SmartTone is having the same package, but for special deal of $100. And now I want to get out of this contract, right? So there are many reasons. Maybe sometimes people want to get out of contracts, right? Or maybe some people cannot fulfill the terms of the contract, and then they face liability because they don't complete the contract as agreed, okay? So basically, you have to make sure that there is no ambiguity. Okay? But of course, ambiguity is good because that means it's just more work for lawyers, because that means both sides will be thinking, oh, what's the wording, what does this mean, right? And remember, especially if you do law, and when you read a lot of the journals, like to prepare for this tutorial, I was looking at a lot of jurisdictions and the journals and problems with contracts, okay? And you will see that, of course, a lot of the stuff that's online in terms of the journals are basically for lawyers telling people out. If you have a problem, you can come and find a lawyer who will help you find the wording, the meaning of the contract, okay? But the main thing is, of course, the importance of the wording. So if you guys come out to practice later on, you will understand what it means. Now, remember when we started off, we looked at standard wording contract. And the examples that you gave me, like insurance policies, telephone or consumer contracts, when you buy things at Fortress, they give you a standard contract, and then can anyone tell me, has anyone actually read any of those terms? Some, okay, some. But sometimes when you go, say you purchase something in Fortress, would you be bothering reading it when you just want to purchase your computer? No, probably not, right? So all you see is really tiny print, and all they say is, please sign here, put the date, thank you, and then they just take it back, and they give you a copy. And then when something happens, then it's like, oh, sorry, this is not covered under the warranty, this is a condition of the contract, we are not going to, we are not liable for the contract, okay? So remember, for standard worded contracts, it's usually harder to challenge it, because if you don't sign, they don't care. You can find someone else, right? Because they have the better bargaining position, okay? So basically, when you are dealing with a standard word contract, you have to read it really, really carefully, because you have no say in the wording, okay? And if you don't comply with the wording of the contract and something goes wrong, then you will be found liable. And you know that for standard worded contracts, it's usually for the benefit of the person giving you the contract. Must be, right? And it's up to you whether you want to be bound or not. If not, then you don't sign, and then you go somewhere else, okay? So the main thing about standard worded contract is that you must read it with extra care, because you can expect that the wording itself may not be for the benefit of you, but it will be more for the benefit of the other side. Now, let's look at a case, because this is an interesting case, because this is this is a South African case, but it's interesting in the way of, remember, the details, the wording in the contract, right? Now, when I was doing the research for this, there was actually, when I looked at a lot of jurisdictions and a lot of different countries, what you focus on is very, very different. And that might mean because of their legislation, their standing, the jurisdiction. Because remember, let's say, for example, America, they've got so many little jurisdictions, and each jurisdiction has their own legal principles in relation to certain things, right? So when you sign a contract with in one jurisdiction, then you have to think, will that apply in other jurisdictions? So there's a little bit more when you look at that sort of wording. But it doesn't matter, because at the end of the day, you still have to look at the wording, okay? Now, in this case, so this case you will see is a South African case. And what happened in this case is that it was dealing with tacit terms. Tacit terms means that the terms are not clear when you read it. Okay, so is it implied into the contract? It's a bit ambiguous, it's not particularly clear. All right. Now, in a lot of contracts, you will see that the wording that is used is provided that. Okay, so what you will have is you will have a contract with a lot of terms on the top. Yeah, okay, so just to say, so you have some idea. Okay, so maybe you'll have a contract, and the contract will say 1, 2, 3, and of course it will have the intro, this is an agreement between and this, okay, and then the date. Now, sometimes you will see that there's all the terms, so these will be the terms of the contract. Remember I told you that a contract has got terms, okay, so we got the terms of the contract. And then somehow in the bottom, it will say provided that, right? And then they may have more terms to the contract, okay? Provided that, is that clear? So it means that there's some contingency before there's a final contract, correct? So you might have to comply with other things before the contract actually crystallizes. So in this case, the key issue that they were looking at and the word that they were focused on, because remember the details in the fine print, is the words provided that. Now remember, why is this case important? And it's a Supreme Court case. Why is that important? Because many contracts have the word provided that, right? So remember, when you look at a contract, the minute you see the word provided that, and let's say you're a lawyer advising, you have to advise on the significance or the problems that may arise when you see the word provided that in a contract, okay? Now, the question here was whether the term provided that is a term of the contract or is it a condition? Because remember, provided that sounds like a condition, right? That you have to comply with it, provided that, okay? Now, remember, as I said to you, City of Tueshwain Metropolitan Municipality and Brooklyn Edge. Who is the plaintiff?
City.
Yeah, City, okay? So I'll just call it MNB, what do I call it? Anyway, we'll see later. Anyway, that's the plaintiff. And then Brooklyn Edge is the defendant, okay? And remember, this is a 2002 decision. So remember, in law, sometimes you have to cite the year and the level of the court, because the higher the court, the more authoritative it is, okay? Now, of course, remember, Hong Kong is a little bit different because Hong Kong, after 97, we don't look at common law jurisdictions, we look at Hong Kong cases, and in particular, the CFA decisions, right? Because Hong Kong is Hong Kong. But other authorities, like from other common law jurisdictions, are persuasive. That means the Hong Kong courts will look at it, but they're not bound by those cases. So they will look at these cases as guidance, okay? And as I've said, many jurisdictions, the law is slightly different, so you have to read the jurisdiction, okay? So what happened here is that the plaintiff, okay, and the defendant, there was a deed of sale. And you know what a deed of sale is, right? It's just basically the sale of the property. And remember, for selling property, it's usually done by way of deed. Now, the property, of course, because it's a property in terms of an immovable property, it was an issue about that part of the property. And remember, in countries like South Africa or like in England, there's a lot, even Hong Kong sometimes, you have rezoning. So let's say something was a commercial zone, now it becomes a residential zone, or this is agricultural zone. So there was the sale dealing with immovable property and in relation to rezoning of that, okay? Now, who could only rezone that particular area? The plaintiff. Okay, it's the city. The city is the only one who can say that this part will now be rezoned to something else. Is that clear? All right. Now, in the contract, in the deed, what was the term that we have to look at, which caused all these problems that this case had to come to court? The word was, provided further that, okay, so provided that, but further that, should the closure and rezoning not be finalized successfully, this transaction shall be deemed to have been mutually cancelled by the parties. Now, just in terms of legal knowledge for you guys when you come out to practice, when you see a word called shall in a term, it means must. Shall. If you see may, then that means it's not firm. But when you see shall, it's must. Okay? Deemed means that it is a deeming provision. That means it will happen. In this situation, this is what will happen. Full stop. There's no more negotiations. But it's called a deeming provision. Is that clear, guys? Okay. So here you can see that if you can't finalize the rezoning, then we will treat that this contract has been cancelled by both sides. Is that clear? Okay. But of course, remember, our focus here was we're looking at the word provided that, right? What does that mean? What does provided that mean? I mean, I know all the other words, they make sense to me, but what does provided mean? Now, later on, the deed of sale, it said, okay, that any property transferred to the nominee of Brooklyn Edge, okay? Now, you know what a nominee is? Nominee means that you nominate somebody to do something, all right? Now, what had happened was, remember, who is the only one who can rezone? City. And what happened here? City failed to take steps to execute the transfer to the nominee, all right, in terms of the rezoning. And then, of course, Pivot, I remember the defendant, the name had changed. It was changed, it was previously known as Pivot, okay? So the defendant then said, I'm commencing legal proceedings, because that is not what we agreed, right? You were the one who had to rezone it, and you failed to take steps. So Pivot was not happy, right? And then they said, no, we want you to comply with the deed of sale, okay? And basically, I want City to rezone, because that is what we agreed under the contract. Why? Because if it is not rezoned, then they cannot take the contract, they can't take the benefit to the contract. Is that clear? Now, of course, if they had known that they would not be rezoning, or something would be happening later on, do you think they would have entered into the contract? If they knew that there would be some problem with the contract later on, that maybe they could not execute the rezoning, would you enter into the contract? Would they enter into the contract? No. Is that clear? Okay. So obviously you can see they're trying to get out of the contract by relying on certain wordings to say, oh, you know, provided that, what does that mean? Now the issue that the court said it had to decide was whether it was a term of the contract or whether it was a condition of the contract. Okay, oh, sorry. Why is that? Because there is a difference between what is the meaning of a term and what is the meaning of a condition of a contract. Now, a condition precedent, and guys, you will learn this when you do law. What is a condition precedent? It's a very specific legal term, condition precedent. So basically, it means that if there is something that is uncertain that happens in future, the contract can be suspended. Okay? Now, if it is a condition, and let's say in the contract, I say this must happen in the contract. It is a condition of this contract. Is that clear, guys? But what happens is that the condition cannot be satisfied. Even though the parties have agreed that that would be the condition, then what happens to the contract? It comes to an end. Because it was a condition, it had to be satisfied, the parties could not satisfy that condition, and therefore the contract ends. Because it's an important term of that contract, okay? Now, if, say, for example, it is a term of the contract, and let's say, for example, there's a party who breaches that contract, then you can seek a remedy for that contract. So I would say, well, I want damages now, right? I want to sue under the contract. I want money, whatever. Okay, so you can see that it's actually very, very different in terms of the effect. Okay, now remember, guys, when you actually study law, there's a whole level, there's another 3-hour lecture on these topics in itself. Okay, but I just need you to know, just for today's purposes, in terms of the reading of the wording of contracts, is basically there's differences between a condition and a term. And therefore, that's why it was so important to define what does provided that mean. Because why? Because it has an effect on the contract. Does the contract end? Or does the contract continue, but then I can get a remedy for the breach of the contract? Now, in the appeal, okay, now this is part of the summary that I got off their website in the Supreme Court of Africa, the website, the press summary. I think it's just easier to read, so you can just have a quick look. So, the city, remember, because city was supposed to do things, and city wasn't happy about how things were happening. So what did they do? They said that the deed of, remember, guys, when you lose a case, you can always appeal, right? You can go up to the next level of court. So this is what they did. When they lost, they went up to the next level of court, and they said that this deed of sale was void, okay? It had no legal effect because it was very vague. It was not clear as to what it meant, okay? Now, the court said at the bottom, you will see, that on the second ground, the Supreme Court of Africa held. Now, held, when you see that word held in judgments, that is the decision of the court. That is the ratio. That is the legal principle of the case. And that is the principle that will be followed in all subsequent cases, if you rely on this case. Is that clear? Okay. So held, so when you see the word held, that was the key to what is the definition of the ratio. The court said, no, the deed of sale was not void for vagueness as alleged by the appellant. Okay, so they said, no, it's clear, very clear as to the wording of the contract. Now, just out of interest, because so you understand a little bit about the arguments raised, because remember, there will always be arguments for both sides, right? So, now don't worry if you don't understand it very detailed, because this is all very legalistic, but just for your idea, okay, what was the arguments that were raised? Citi said this was a condition of the contract. So the clause that we saw just now, they said it is a condition. It's not a term. That was their argument. And why did they say that? Because they said, look, we had to rezone, but we never said when we had to do it, right? There was plenty of time, because we didn't say that it had to be done within the end of the month, or it had to be done within 2 years of signing of the contract. There's no clear term as to the period, okay? So they said there was no exact date stated on the contract. The court disagreed. The court said no. The court said that when you look at the word, provided that, you must look at it in the whole context of the case. Is that clear? And not just simply, oh, because the word looks like a condition, therefore the whole contract is suspended and it lapses. No. The court said you have to look at the whole background to the case, the understanding between the parties. And remember, certain things in contracts, it must mean that it has to be done quickly, right? It can't mean that you're going to wait 20 years before the contract actually is effected, correct? So you can't be assuming that, oh, because it doesn't say when the rezoning has to be done, you can wait 40 years. Does that make sense? No, okay? So that was what the court said, okay? They tried to argue that suspensive, sorry, I spelled this, a spelling mistake. Anyway, Tiffany can give you the PowerPoints later, after I meant it, okay, this was a typo mistake. Suspensive condition, okay, their argument, the court said, is not successful in terms of the argument, okay? Is that clear? So you can see actually that just 2 words, provided that, has a huge implication on the whole contract. And remember, this is like big contracts, correct? So basically always remember that when you're reading contracts, when you're drafting contracts in particular, even if you want to be solicitors or barristers, so let's say if a solicitor, what normally happens is solicitors will draft the first step of the contract, right? Then the barristers will get the contract and they finalize it. So remember, if you don't know how to draft, or if you fail to understand the implications of certain wordings, then it affects the whole contract. And remember, we all will be personally liable. Barristers will be sued. We all have to take out insurance. Solicitors will be sued as well. And how do you know whether something is correct or wrong? Legal research. And again, that is another 3-day lecture on how to do legal research. Maybe I'll do that next time with Tiffany. We'll do a course on legal research. But remember, guys, when you come into practice, you have to do your legal research. Okay? And that means looking at cases. So anyway, just to confirm, the court said that this was a term and it was not a condition. The contract had not lapsed. And again, the test is the reasonable person. So a reasonable person looking at the background, looking in on the contract, what is the reasonable person's view in the context? Is that clear? Okay, right. And remember, what is it that you look at? Is that before signing the contract, would the parties have agreed to that term if they had known that the rezoning would be indefinite? There would be no date as to when the rezoning would be done. Would you sign? No. Okay. Okay, so basically, remember, when a court is looking at the contract, it must mean that you are giving it business efficacy, which means basically you want to make sure that it will be executed, that will allow the contract to have legal effect, and also which would cover the intention of the parties when they enter into the business contract in the commercial world. Is that clear, guys? Okay. So again, what did the court say? You look at what is the intention of the parties. And how do you know what is the intention, guys? I said, because it's all in your head, but how do you know? By what's said, contents, okay, what you said, and in writing. So here, what do we have? In writing, right? So that's why they looked at the word and then they looked at the intent, okay? Now, remember, what was the document here that the court looked at to find what was the intention between the parties? What is it called? The deed of sale. Okay, so that is what the court looked at. All right. So basically, what do you want to take away from this, guys? Now, this was a case where you had to look at the proviso. Okay, so basically the provisions of the case. So remember, do you know what proviso means? Proviso means that provided that. Okay, but another way of explaining it is also called a proviso. Okay, so remember, as I've said, what you remember that you need to know is that you always must check the wording and the terms and the effect of the policy. Okay, the court will not try to assist the parties in trying to understand what the parties would have meant. That is not the role of the court. Okay, so that means you guys have to make sure that the words are clear. Now, things that you have to know. Now, normally when you look at contracts, what are the things that you will have to focus on in relation to the wording? So say, for example, time frames. Do you have a time period in the contract? Do you say that, oh, this contract will last for a period of 12 months, right? Or this contract must be, the terms of the contract must be complied with within 1 week. So remember, always look in the contract to see, have you complied with putting time frames in the contracts? Are there any vague wording? Now remember, as to how wordings are written, you must look at case law. You must look at other cases to see, in other cases, what were the problematic wordings and whether you have to amend your one when you are drafting something, all right? And also, remember, when you are drafting, there is a thing that you're trying to achieve when you draft that contract. Must be, right? As I said, you're not drafting it just for fun, right? You're drafting it because there is something that you want to happen under the contract and you want to make sure it happens. But remember, if your wording is not clear, then it will not happen. Now, just other situations where we have had wording issues and like, how do you deal with, remember COVID? Yeah, I'm sure everybody remembers COVID. Now, in contracts, you will see that there is this word called force majeure clause, all right? It's quite standard. You will see that in a lot of contracts. Force majeure basically means that you cannot see something that will happen in the future, and it is unforeseen. All right? So it is an unforeseen event that the parties cannot have foreseen. And COVID was one of them, right? Because it suddenly happened. And of course, it had huge impact on contracts, right? Huge impact on general life generally. Other things which could be under force majeure is, say, for example, act of God, right? Hurricanes, earthquakes, stuff like that, okay? Now remember, there usually isn't like a clear definition of these type of wordings. So again, remember, if you're drafting force majeure clauses, for example, you have to make sure that you have defined the wording and the details carefully. Remember, just to loop it back to what we have started off with when we started off today's today's lecture is, if you are relying on it, you have to, you have to prove it, okay? So remember, if it's a force majeure clause, you have to show that certain things were beyond your control. But remember, for force majeure clauses, you have to mitigate. Mitigate means that you have to do everything possible to reduce the loss, to reduce the damage. You can't just sit there and just let it happen and then just say, oh, I don't know what happened, God came, acts of God and this. No, right? You have to do something to mitigate. That means to reduce that loss. And therefore, you also have to show that maybe, see, I tried to fulfill my contract, my part of the contract, but for certain circumstances of unforeseen events, it just did not happen, but I mitigated my loss. Okay? Now remember, again, there are cases authorities on this. Basically, it says that if you're relying on the force majeure, it has to be the only cause of why the contract ended. Is that clear? If there are other reasons why the contract could have ended, then you cannot rely on the clause. Is that clear? So again, my point is, for force majeure clauses, because that is a clause that you will see very frequently in the contracts, right? My point is, you have to read the wordings and you have to draft those clauses very, very carefully. But generally, if, let's say, for example, if it's not because of a force majeure, some unforeseen act that has happened, then you can't rely on it. Is that clear? Okay. Okay, so how to avoid problems just generally. So we now have an idea of what are the problems with contracts. What do you have to look at when you're drafting contracts, okay? Usually for contracts, it's always good to have a definition section. So when you define in the intro all the wordings that you think are important, which recur in the contracts, then it's better to put it in a definition section because they're important terms that have to be defined. So if anything happens, there will be no problem between the parties as to what is the meaning of that. The next thing is that in contracts, you will see something that are terms, conditions, and warranties. Now, each of these have got different meanings. So when you read the contract, you need to know what exactly is the effect of that term, effect of that clause, okay? Payments. Let's say, for example, if you're dealing with a contract which involves payments, what happens if you can't pay, right? What is the liability? You need to cover that in your contract, okay? Information. Now, the more detailed the contract, of course, the better, right? But of course, on the other hand, the more detailed the contract, the harder it is to argue differently when something goes wrong. So sometimes you'll see contracts that are drafted quite vaguely, quite broadly, right? Then parties can argue, oh, this was the meaning at the time, we didn't state it very clearly, but that is what we were intending. That is the effect of it, okay? So remember, of course, the more details, the clearer it is, the better. So give us a judgment call. Now, indemnities in relation to loss that has been suffered, you will see that sometimes in the contracts, they will provide for indemnity, that therefore will be indemnified for losses that have been incurred, right? That will be a term in the contract. Okay, so maybe I will say that Ms. Mohammed, if there's a breach of the contract, will be indemnified by the student for the loss that has been incurred. All right, so that you will see that sometimes there's indemnity. So again, if there's indemnity, see how wide you want to draft it or narrow you think it should be drafted. Now, insurance policies, as mentioned by the students, those are contracts which are, I think, more general, where you can see that there's a lot of wording. And the minute you have an insurance claim, what do they say? Oh, if you look at paragraph 14 of the contract, it says, therefore, we exclude no payment by, right? Insurance contracts are always like that. They say, we're not covered. That's not the wording, not covered. Okay. Now, just generally in relation to the wording, now this is an example of the force majeure, but remember, what does the court say? It is a matter of the language. In relation to the reasonable endeavors is a phrase which enables account to be taken of all matters which bear upon the question, whether it is reasonable to expect a party to take certain steps to avoid or circumvent a force majeure. So in the example of force majeure, for example, the court is saying, you look at the language, the wording, how something is expressed. Is it reasonable to expect that the person should take action? Because remember I told you force majeure is that you have to mitigate, right? So again, to avoid the force majeure, what should they have done? Have they done it? So again, it has to be very clear. Okay? Now, real estate cases, so I've covered with you insurance cases. Now, real estate cases, now that's a little bit different because, say, for example, those are like written agreements in relation to the property. The main thing you normally would have to check is the enforceability of the wording, okay? And now remember, this is also a whole different area. Now, this is more popular in America because there's a lot of like real estate, like massive plots of land and stuff. And in those terms, if you look at their type of contracts, they are so complicated, extremely complicated, all right? Because, you know, you've got a broker, they got commission, they got deals, and then the wording of the contract. So my point is just make sure that when you read the words, it has the effect of enforceability if anything goes wrong. And remember, you have to look if you're safeguarding whose interests in the contract. Okay, so which angle do you consider the wording? Now again, as I've said, guys, as you mentioned to me at the start already, there are many different people, parties to a contract, employee, consumer products, people who own businesses who enter into contracts, sole proprietors. Say, for example, I'm selling my watch. Same thing, right? Businesses. So these are the type of people. So in everyday life, you have to worry about wording and clauses, okay? So it's not something that only lawyers have to be concerned about. Everybody has to be concerned about. Now, should I care? Should you care about the small print? Well, I don't care, you know, I just read the prints and that's it. But of course, I'm a bit more careful because before I put my signature, I will read the document carefully because it's a bit embarrassing if you're a lawyer and then you sign something and then you say, oh, sorry, I didn't realize these were the terms, right? Format. Now remember, a lot of the contracts in terms of the formatting, especially like standard worded, are really tiny. Nobody can read them, right? They're like, you need a magnifying glass, correct? But again, the format of documents, people have to be careful because sometimes the way clauses are drafted may not be clear enough. There may be cross-referencing. Different clauses may say, oh, this is part one. But then if you look at part two, there's slightly different wording, which will affect part one, right? So again, please look at the format of the contracts, okay? And the clauses, as I've said, because clauses usually have things in relation to liabilities, which is all what you will be concerned about because you don't want liabilities. Now, why bother reading? So basically, when you have a client that comes to you with contracts, or say, for example, before they sign the contract, you will tell the client, please read the contract yourself. Please make sure that you are satisfied that your rights are being protected under the contract, right? You, of course, as a legal advisor, have to make sure that the wording has been properly scrutinized. That means the wording is there that protects the interests. And you advise on the consequences if there is a breach of the contract. And remember, when you sign contracts, they always tell you, right? Like if you fail to comply with the contract, then therefore, you know, what will happen? And of course, remember, the main thing is that when you sign the document, you have to be making an informed decision. That means you must fully understand the implications of what you are signing. And if you're a lawyer, that is something you will have to advise the client. Okay? And remember, you always have to explain the wording to the client. So if you don't understand the wording, then you have a big problem. Right? Okay? So basically, if you have read everything, and if, say, for example, the wording is very clear, what can you avoid? Litigation. Right? But of course, that's a good thing for us because then we may make money, right? Because there's litigation in court. Liabilities, because then you don't be sued if anything goes wrong. And of course, more importantly, you avoid any disputes arising in future because the wording is so clear. Okay? That's it. Good. Do you guys have any questions?
Yeah, do you have any question for Nisha?
No.
No? Yeah, you have one.
I'm concerned about the rental deal because when you rent a flat, sometimes maybe some private owner,
Yeah.
she may be not a lawyer probably, and she just made a deal with you. So maybe you can have a say in the contract. So.
But usually for rentals, they always go to the stationery shop if it's like an old lady who will
Yeah,
get the standard
yeah.
worded rental deal contracts.
Yeah.
Yeah, and then it's just you sign because it's quite simple. It's basically how much you will pay per month.
Yeah.
But I think usually the biggest problem is the break clause
Yeah.
in the tenancy.
That was included.
Yeah, because I noticed that like sometimes when people come and ask me, I know sometimes the break clause is not clearly defined. So, but to answer your question, if it's standard wording, you have to sign unless you draft a totally new document. That's okay, but then she or the landlady would have to agree to that, and I wouldn't. I just get to the stationery shop and draft them. Why would I be? I've got no knowledge in law. Why would I be drafting? Right? And she probably won't trust you because you're studying law.
I have got another question because my job is a claims clerk for a brokers. That's why some of the customer may need to do the claims. One time it is about a travel claims. Normally the contract have said they cover the delays, flight delays due to bad weathers. And if the delays time exceed more than 6 hours, they will compensate or indemnify, have a cash allowance for my client. One time is that just after the hangings of typhoon signal number 10, and then the insurer has informed everyone that on their website, on their pop-up message, the delays due to the typhoon number 10s will no longer be covered because of the notice. So one of the customers didn't serve their NAS, didn't read the notice, and then later on when she do the claims, the insurance company declined them due to the notice. So will the pop-up message or the notice will be tracked as part of the contracts in this condition?
Right, but it depends on whether the original contract would say that, please stay up to date with our policies, which would usually be on their website. It depends on how it's drafted, right? And also notification. If it's something that when you sign, they don't actually ever tell you, please look at our website, then maybe you can argue, where I didn't get notification of this term. But remember, with those type of companies, they will always say, you have to look at our website, right? As to if there are any changes which may affect it. And look at the contract wording. They may say also, there may be some things that may not be included, but you have to ask, right? Yeah, so I think that's arguable.
Arguable?
Yeah, arguable.
So which part of the contract will be the wordings to arguable for those kind of so-called notice or notifications?
Well, I think in the contracts, unless they state clearly that there may be things that happen which are not actually, because sometimes you cannot foresee, right? Unless, say, for example, in that part of the term, they say what are the situations which will be covered or not covered. Then if they have so detailed written it out, then it's harder to argue because you will say these are only included in this section. Anything outside is totally different, and I'm entitled to claim, right? But if it's done in a very general way, which is like, please stay up to date with our notices on our website, or look at our Instagram, Facebook, stuff like that, then it's harder to argue because they've already told you have to look.
But if they don't tell, we can argue that this is not part of the contract.
Yeah, you can say because is the website part of the contract? Or did they tell you that? Please make sure that you keep up to date with any amendments to the policy because it may be on the website. Yeah, so that's why law is always something that always is arguable.
Any more question? Another question popped up in my mind related to our daily lives that we apply the forms, or for example we apply a new bank card, etc. Is that a contract? I mean, yeah, because there are lots of terms that you have to scroll
Yes,
down.
it is a contract because the minute you sign on it, it becomes the contract.
But we didn't sign, we just press the press the button and say, oh, we agree. So
Yeah, that's it. I accept.
Yeah.
Yeah, the second thing.
Electronic device.
That's fine, I accept.
Yeah.
And they make sure that if you don't accept, they don't let you go to the next page anyway.
Yeah.
Yeah, of course. They have to make sure you accept and understand. Then you're bound.
Thank you.
Well, thank you very much, Nisha. So, for those who came late, Nisha was actually our graduate, our University of London LLB graduate, and she is now a Hong Kong and UK barrister, and she is also a teacher for the PCL advocacy courses, and tonight she's flying out to University of Oxford and do the advocacy training. So she is also our tutor for the University of London Cert HE program, the Certificate of Higher Education in Common Law. So this program is basically equals to London ULLB Year 1. So thanks to Nisha's effort, our student has attained 100% pass rate for the past 2 years. So thank you very much for Nisha. For those who found this talk probably confusing or you don't understand, which is normal because Nisha is given a higher level of contract law. She is not even talking about the contract law 101 or overview of the contract law, but a higher level. She looked into the details and also the terms and conditions and the wordings. So a lot of students would underestimate the complexity of contract law, which as you can see, contract law can be very complicated. So Nisha would be very helpful to explain to our students like how's contract law and other laws. So if you're interested in studying law, please apply to our program. All right, thank you very much. Danny is our college head.
You taught me too.
Yeah. Oh, you taught Nisha too. Oh, teachers and
The
teachers.
main point is I am college head right now, but I'm an alumni of law programs here also. I started out as a part-time student, actually not quite on the same course, but on a similar course, and I ended up running the college. So maybe come and join, come and study, right? And then I'm old, right? I have to retire at some point, right? 10 years, 15 years time, you could be running part of Hong Kong Space.
Yeah, you could be teaching.
Yeah, thank you. A very promising future here. Studying with us. Thank you very much. Thank you.